Well, hi, everybody. Today, as you all know, we find ourselves on the heels of yet another historic victory for Alabama's Black voters and for democracy itself. Earlier this morning, a federal court struck down the Alabama State Legislature 2023 redistricting plan and ordered a special master to fairly redraw our congressional maps. This decision represents a major step towards equity and fair representation for Black Alabamians. As we all know, earlier this year in the Milligan case, the Supreme Court rejected Alabama's congressional map and ordered the state to redraw its map with at least 2 majority-minority districts, or, quote, something quite close to it. Those were the words of the Supreme Court, not my words. 2 majority-minority districts, or, quote, something quite close to it. After all, Black Alabamians represent nearly 27% of the voting age population, and yet they have the opportunity to elect a candidate of their choice in only one of our 7 districts. Do the math. That's 14% representation, not fair representation. Despite the Supreme Court's clear directive, we watched as the Alabama Supreme Court openly, and I might add brazenly, defied the court and enacted a remedial plan with only 1 majority-minority district and a second district where African Americans make up only 39.9% of the voting age population. From the very beginning, we knew that this map did not comply with the Supreme Court's order. In fact, I believe it is a great insult to Alabama voters across this state that our state legislature didn't even try to meet the Supreme Court's demands. But with today's ruling, justice has once again prevailed. By appointing a special master to fairly redraw Alabama's congressional map, the court has rejected the state's legislature's last attempt to dilute the voice and the voting strength of African American voters in Alabama. While we were outraged by the state legislature's open defiance of the Supreme Court originally, I know that I am grateful today that a federal court has now intervened to protect the voices of Alabama's Black voters. Not only does this decision pave the way for more fair representation for Black voters, but it also affirms that the Voting Rights Act of 1965 is alive and enforceable. Let me be clear. We in Alabama are no stranger to the fight for fair representation. We know that Alabama State Legislature has a long and painful history of waging war on the rights and freedoms of Black voters, and this is only the latest battle. But today's victory shows that when we come together, when we use our voices to stand up for what is right, when we get into what John Lewis would call good trouble, we can make a difference. Above all, this is about fairness. It's about ensuring that all Alabamians, all voters, regardless of their race or zip code, get an equal opportunity to make their voices heard and elect candidates that will represent their interests. As we look to the future, we know that the special master will draw several maps. In fact, the court order said that the special master will draw 3 maps and submit them by September 25th. And on October 3rd, there will be a hearing on those maps. I do fully expect that the court will adhere to the aggressive timeline that has been established to ensure that a new fair congressional map is adopted in time for the 2024 election. Make no mistake, our fight is far from over. While the Supreme Court did uphold Section 2 of the Voting Rights Act, Section 4 and Section 5 remain gutted, and states remain free to target voters with discriminatory voting restriction against minority voters. What we need is the full restoration of the Voting Rights Act of 1965. After all, it was our district that brought us the Voting Rights Act of 1965, and I think it's important that our district actually restores the full protections of the Voting Rights Act. That's why later this month, when the House of Representatives goes back into session, I will reintroduce the John Robert Lewis Voting Rights Advancement Act in the House of Representatives to fully restore the protections of the Voting Rights Act of 1965. This bill will protect the right to vote and safeguard our democracy by preventing restrictive discriminatory voting laws from ever coming into effect. We know that with a Republican-controlled House, passing the John Robert Lewis Voting Rights Advancement Act will be an uphill battle. But know that your Congresswoman will be fighting tooth and nail to get this legislation brought to the floor. In the words of John Lewis, the vote is precious. It's almost sacred. It is the most fundamentally nonviolent tool that we have in our democracy. It has been the honor of a lifetime for me to represent my home district in Congress. It is a responsibility that I do not take lightly, but I know that fair representation means that we get an additional voice in our nation's Congress, fighting for Black Alabamians. So long as there is breath in my body, I will never stop fighting for that most sacred right to vote. And with that, I'll open it up for a few questions.
Just wanted to first and foremost ask, we saw the Attorney General make a statement saying they intend to promptly seek review from the Supreme Court. Is that your expectation that we're going to continue to see this legal battle persist all the way back to the Supreme Court?
I do. It is the right of the state to appeal the injunctive order that was released today. So I fully expect, and in fact, the AG said that he would be filing an appeal on this motion. He's probably going to file a motion to stay the injunction. And so I suspect that this legal battle will go on. And I think that it will go on concurrently as the special master draws the maps. The order from today was pretty clear that they're given until September 25th to submit 3 maps. And so I'm assuming that that this legal battle will go on concurrently with the drawing of the maps. Great. Look, this is all about democracy. It's about fairness. When I don't think that you can fully appreciate my district without knowing the history, the very painful history of racism, discrimination, segregation, and disenfranchisement that we in Alabama, Black voters in Alabama, have experienced in my lifetime. And so I think that it's important that we continue this fight. But I am very happy that the Supreme Court very emphatically said that the Voting Rights Act of 1965 is still very much alive and enforceable, and that Section 2 will stop state legislatures across this country from diluting the power and the strength of minority voters.
Just, the report itself, or the court order, is over 200 pages long, and some of it is just pretty scathing. And I just want to get your thoughts on some of the comments that you see, or some of the opinions in it. And one of them, we're disturbed by the evidence that the state delayed remedial proceedings, but ultimately did not even nurture the ambition to provide the required remedy. And we are struck by the extraordinary circumstances we face. What are your thoughts on just how scathing some of the comments in that report were, and perhaps by the lack of state action?
Yeah. I thought that the 200 plus report from the court today, the judges went through all of the evidence and painstakingly said that our state legislature, in defiance, did not adhere to their order or the Supreme Court's order. And I have to tell you that I was surprised by that, because I think that taking this and putting it in the hands of a special master and out of the hands of the state legislature, I would have thought that that's something that our state legislature would not have wanted to do, and would have worked to try to meet in the middle, and to try to figure out a way that they could comply with the Supreme Court. So, we are where we are. And I think that where we are is, I do believe that we will get to a fair representation in our maps, and that may come at the cost of more litigation. It saddens me that, irrespective of political party, we should all be about making sure that every Alabamian who's 18 years old has an opportunity to cast that most important ballot. That's their citizenship. That's their ticket to civic engagement and participation. And no one should be denied that. And when you think about the fact that African Americans make up 27% of the population in our state, the voting population in our state. And we have 7 seats, and there's only 1 seat that gives African Americans an opportunity to choose a candidate of their own choosing. And I think that that's important because, I think that when we look to really understand the basis of our democracy, the cornerstone is that right to vote. And so, as John would say, it's precious, it's almost sacred, and we should do everything in our power to fight to make sure that everyone gets to exercise that franchise. And so that's what I believe this lawsuit is about. And that's definitely why I will be reintroducing the John Robert Lewis Voting Rights Advancement Act, because while Section 2 of the Voting Rights Act was upheld in the Milligan case, we still have lots of states that go unchecked and have restrictive voting laws. And so, I believe that if one person who should have the right to vote is denied that right and that access, that does affect all of our democracy. I think it's important that we continue to make sure that that's first and foremost and top of mind in what we're doing.
Thank you, Congresswoman.